You may have a seat. We are set today for a plea and sentence. I know we tried this back on the 22nd, and some questions came up, in particular, possibility of double jeopardy. I have reviewed.
Double jeopardy, huh? That's a big legal buzzword, so let's break it down. It means you can't be tried twice for the same crime. But here's the key. It doesn't apply unless there's been a formal trial and verdict. Since that didn't happen here, the judge's ruling checks out. Still, it's a bold defense move. Smart or just a Hail Mary? You decide.
Reviewed and done my own research. I don't believe that applies here. But I'll leave up to counsel to argue otherwise if they feel as though that's necessary. Mr. Hartel?
I don't feel like he's allowed to show that.
Ms. Gary? All right. So it's my understanding we have a plea agreement in this case. And my understanding is that the defendant will plead no contest to all counts as charged. Is that correct?
That would be the understanding.
All right. Ms. Carey, I believe I returned your exhibit last time we were here. Actually, I think Mr. Collins was covering it. Do you have that? Mr. Moore, while she's looking for that, will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. All right. It's my understanding then that you're pleading no contest to all counts 1 through 4. Count number 1 being computers using a crime to commit an offense with a maximum imprisonment of 1 year or less. That is a 1-year misdemeanor and or a $5,000 fine. Reimbursement to the government for expenses incurred, and consecutive sentencing may be imposed for the underlying conviction. In count number 2, you'll plead no contest to telecommunications malicious use. Regarding Ms. Carla Filkins, that is a 6-month misdemeanor and or a fine of $1,000. In count number 3, you plead no contest, telecommunications services malicious use. Regarding Marcus Pesha, that is a 6-month misdemeanor and or a fine of $1,000. And then in count number 4, it is alleged, or I'm sorry, you would plead no contest to telecommunications malicious use in regards.
Notice how the defendant locks in a no contest plea to avoid civil liability? That's a classic legal tactic. He's not saying I did it, but he's letting the court treat it like he did. It's like saying, I won't fight this, but don't sue me later. Clever? Maybe. But it also raises a question. If you're not guilty, why plead at all?
Regards to Renee Pesha, that again is a 6-month misdemeanor and or a fine of $1,000. Is that your understanding of how the case will be resolved today?
If I may, Your Honor, there's also the event that the other pieces without you.
Correct. Thank you for that. And so, additionally, there were no charges arising out of the Wexford County Police Report 83-25-00625 or the City of Cadillac Police Report. Ms. Carey, do you have that number? It ran into other letters on my sheet, and I can't read what it says. You know, it's a 25. I want to say 804, maybe 884. Okay, so it all arises out of the same occurrence?
Correct.
All right. Mr. Moore, is that now your understanding of the plea agreement? And is that a full and accurate recitation of the plea agreement? And I know we went through this last time, but I still need to cover it today. Did you read and sign the advice of rights form? Talked about your rights to an attorney and your rights to a trial. Did you understand those rights?
Sir.
And do you understand that by entering a no contest plea today, you'll be waiving those rights and you won't have a trial of any kind?
Sir.
Has anybody promised you anything in order to get you to plea today other than the agreement? Has anybody threatened you in order to get you to plea? And is it your own free choice to plead today? Now, do you understand that by entering a no contest plea, that it will allow the court to review in this case, a police report, which was already admitted as People's Exhibit number 1. I'll be able to use that to determine whether or not there's a factual basis and whether or not, and to use that for sentencing purposes. Do you understand that?
Sir.
Additionally, the reason for the no contest plea is for potential civil liability. So if any persons listed in the complaint decide that they want to sue you civilly, a guilty plea could be used against you. This would allow you to accept the responsibility as if you are guilty without saying you're guilty. Do you understand that? Then to the allegation that on or about January 21st, 2025, here in the city of Cadillac in Wexford County, in count number 1, that you did use a computer to commit a crime with a maximum imprisonment of 1 year or less, in particular, malicious use of a telecommunications device. How do you plead? Count number 2, malicious use of telecommunications services in regards to Carla Filkins. How do you plead? In count number 3, malicious use of telecommunications services in regard to Marcus Pescia. How do you plead? And in count number 4, malicious use of telecommunications services in regards to Renee Pescia. How do you plead? Last time we were here, I had the opportunity to review People's Exhibit number 1. Counsel, do you believe that People's Exhibit number 1 forms a factual basis in which to accept the plea?
I do. Your Honor.
And that the court rules have been complied with?
Yes, sir. Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. In particular, Mr. Moore, I find that back on January 21st of this year, you had sent messages, and those messages were threatening in nature.
Yikes. That was no ordinary rant. This wasn't just angry typing, these were graphic, calculated threats. Now ask yourself, if you got a message like that in the middle of the night, how would you feel? Safe? Protected? Probably not. And, legally speaking, intent to terrorize doesn't require a weapon, just words sharp enough to cut through safety.
I'm sorry, People's Exhibit number 1 also includes the Michigan Department of State Police, incident number 6441025. In particular, to the message that was sent to Ms. Filkins, it states as follows: "You're going to do something about the water in Cadillac, or what, you stupid, dumb bitch? You'll be lucky if one scary night someone don't come to your home and pull you from your sleep, pull you to the street, put a bullet in your head, you corrupt, dumb bitch." Additionally, there was a message sent to Mr. Pasha that says, "Just seen your wife reporting city council meetings on Facebook. You, sir, and your dumb little bitch of a wife should be pulled from your house while you sleep and a bullet put in your head. You're scumbag, corrupt loser, bitch, who should be shot dead in front of the whole community of Cadillac just to show an example. Your wife is a scumbag, corrupt loser, or bitch too, you stupid fat fuck." I apologize for the language that was used, but I believe it's appropriate to place that language on the record to get the defendant's full intent when sending those messages. It's also my belief, based on the reading of the reports, that those had come in through a Facebook messenger.
Here's a crucial nuance. The defendant says it was an emotional overreaction, no real plan to follow through. But in Michigan law, intent isn't about what he meant to do. It's about what a reasonable person would feel after reading those threats. And based on what we've heard, it sounds like fear was the only logical reaction.
Messenger, which would meet the requirements for use of a computer to commit the crime. And additionally, I also find that these messages were sent to or regarding all persons involved, that all persons involved would have seen these messages, and that they were sent with the intent to terrorize, frighten, intimidate, harass, or disturb the peace of each of these individuals. Additionally, I find that based on my reading of the report and by defendant's own admission, me just find this here. He also admits to sending the messages um, and classifies them as an emotional overreaction, but had no plan to follow through with the threats. While he had no plan to follow through with the threats, at least as he describes, I do find that based on recent case law arising out of the Michigan Court of Appeals and the Michigan Supreme Court, I believe that these messages do show the intent of sending the messages was to threaten, terrorize, harass these individuals, and that the defendant knew that when sending those messages, that is the effect they would have. As such, Mr. Moore, I find you guilty in count number one of using a computer to commit a crime with a maximum imprisonment of 1 year, which is a telecommunications services malicious use. Count number two, telecommunications services malicious use regarding Ms. Filkin. Count three, telecommunications malicious use regarding Marcus Pesha. And count four, telecommunications malicious use regarding Renee Pesha. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea, in that a guilty plea could be used against him in a potential civil liability case. I also find that the plea is knowing, voluntary, and accurate. Pursuant to the plea agreement, those additional cases will not be brought. Ms. Carey, are we able to sentence today?
Yeah, we have two of them that you would.
All right. Who wants to go first? Mr. Pesha, could you just state your name for the record, please? And what is it you would like the court to know?
Thank you. Here to the officials of the court. Your Honor, once you have the words weaponized, words of consequence. Here today, Mr. Moore read words on a social media platform posted by people that, in my opinion, was published to make the environment chaos and environment to facilitate without accident or the militia spreading of lies, misinformation, and attacks on my and my wife's character and character. Yeah, we can't do weaponized, nor they do have consequences. Mr. Moore read those words, reached out to a variety of messages to contact me or a member of my staff.
This is the real weight of online threats. Not just hurt feelings, but literal panic. Canceled plans, sleepless nights, fear for your family. Words aren't harmless when they shatter someone's sense of safety. And here, the victims are painting a devastating picture of emotional fallout.
Or a member of any number of state agencies or even a federal. Information and would provide the factual truth of what was being in my opinion falsely propagated on social media. Correct. Mr. Moore did not reach out to me first. Rather, Mr. Moore directly messaged me on the social media platforms to threaten me and my wife. The freedoms I understand also posted profoundly alarming, disgusting threats that at least one publicly available social media for an unlimited number of see, share, and spread. All things that could have led to, still could lead to, certain violent outcomes. Mr. Moore's actions have detrimentally impacted my life and my wife's. Mr. Moore's actions have also had a negative effect on my children, my family, my friends, and even colleagues. Mr. Moore's actions have stress, anxiety, An emotional roller coaster of feelings. The shock and horror received words about my wife and I drug out of bed, middle of the night, dragged to the streets, shot that night, and displayed at the town square, and I do have an ego. Stress, sleepless nights, being on edge. You're still with me. You're still with my wife and others. Later, Mr. Moore has exemplified stuff. It is not okay. Nor is it something that can be simply forgotten to be honest. Words have meaning. Words can be weaponized. Words have consequences. I appreciate your words.
Thank you. So,
Good afternoon, Your Honor. This is on the court. I came today not with a prepared statement. I would like to be clear. Words do matter. And Jamie Moore chose to use his words for harm and for evil. And that impacted my family, my 85-year-old mother, my son, who is an army, my other children, and grandchildren. It impacted me. It was a game changer for me. I worked in the city of Cadillac for 11 years with tremendous honor. But when I received this death threat for caring for my community over things that Mr. Moore read on Facebook and other social media that weren't necessarily true, people were just putting their words out there because that's what they can do on social media. And on January 21st, very first thing before I walked out of the house that morning, I received that message from Mr. Moore. I'm terrified. Called my husband home, called the public safety director, and we spent the rest of the day not planning for a business that we needed to conduct that evening in the city of Cadillac. We spent our day trying to, first of all, understand what was happening. How do we take care of our community with these types of threats coming forward to us? It wasn't just about us. It was about people that are out there that can do such horrendous things with their words. And I just hope to understand what that's done.
thank you both. Elocution, Mr. Hartel?
Yes.
Well, first of all, I had ordered a pre-sentence investigation report on this. Did both parties receive that?
Yes.
Mr. Hartel?
I didn't want.
All right. Elocution?
Yes, thank you, Your Honor. Anytime there's civil liability possibilities for no contest, obviously affects consequences for reality. However, I have discussions with my client quite a bit about the situation. I would ask the court to equally factor in goals of whatever punishment is given. I believe that the supervision, any concern the court may have for education of my clients, public safety, can be incorporated into terms of that probation. I realize that recommendation for jail sentence, DSI, and the reasoning was explained in that as well. I certainly asked the court not to give a higher amount than was recommended with DSI. I realize the court could. But I would ask the court still.
The defense pivots here, shifting the spotlight from the crime to the character. Hardworking, punctual, paint on his clothes, a regular guy narrative. But here's the tension. Can someone still be dangerous even if they look like a productive citizen? That's the question the court and you have to wrestle with.